All right, let's pull back the curtain on a pretty hidden legal world, one where huge corporations can actually sue entire countries for billions of dollars. It's called international investment arbitration. Now, the system was designed to protect massive overseas investments, but it brings up a huge question. Is it a necessary safety net for the global economy, or is it a threat to a country's own power? Let's dive in. So to really get this, you first have to understand the enormous risk involved when a company invests abroad. I mean, think about it. A company pours billions into building a massive new factory or a power plant in a foreign country. They're not just betting on their project being a success, they're betting on the fairness and stability of a whole other government. And that really gets to the heart of the problem. Imagine your company just spent $1 billion building a brand new telecommunications network. Then, boom, a new government comes into power, decides to nationalize the whole industry, and seizes everything you've built. Just like that, your investment is gone. What do? Where do you even begin? So, what are your options? Well, the two most obvious paths are, more often than not, total dead ends. You can't just sue the foreign government in your own home country's courts. They're protected by this powerful legal shield called sovereign immunity. But then suing in the host country's courts, that's a huge gamble. You could be up against a biased legal system, intense political pressure. A fair trial might be next to impossible. Let's just break down sovereign immunity for a second. It's a basic principle of international law that says, one nation's courts can't sit in judgment of another nation's government unless that government agrees to it. So for an investor who just had their assets taken, this principle is just a massive legal wall. So if the legal options were so limited, what used to happen? Well, historically, before we had a neutral system, disputes were often settled by force. Seriously, if a country seized foreign assets, the investor's home nation might literally send warships. This was the era of gunboat diplomacy, using military power to protect economic interests. You can see why a more peaceful solution was desperately needed. And this need for a peaceful way forward, well, it led to the creation of a global safety net. Over decades, the international community slowly pieced together a legal framework that could protect investors without having to resort to threats of war. Now, this journey took a while. Right after World War II, there were some early treaties that offered a little protection, but the big efforts didn't really go anywhere. But then, in the 1960s, we had a breakthrough, the first bilateral investment treaty, or BIT. This new model, focused only on investment, really took off, and by the 1990s, you had what's called the BIT explosion, with countries all over the world signing these agreements. So, what exactly is a BIT? Well, it's an agreement between two countries, and it makes a bunch of promises to each other's investors. But the most revolutionary part, the real game changer, is that last clause. The states agree ahead of time to solve disputes through binding arbitration. That right there is the key that unlocks this entire system. See, by agreeing to arbitration in one of these treaties, the state is basically creating a neutral playing field. It's saying, okay, we agree to let a third party, an independent tribunal, come in and act as a referee to solve any disputes we have with a foreign investor. Now, it's so important to understand that this is not the same as the kind of arbitration you hear about in normal business disputes. That usually involves two companies arguing over a contract. Investment arbitration is a whole different beast. Here, you have an investor suing an entire country for breaking an international treaty. The stakes are way, way higher, because these cases can challenge national laws on everything from public health to protecting the environment. And the main place where these cases are heard is the International Center for Settlement of Investment Disputes, or as everyone calls it, ICED. It's actually part of the World Bank Group, and it was created specifically to be a neutral forum for these super high-stakes disputes. The process itself usually follows four main steps. First, the investor files a claim. Then, a neutral, three-person tribunal is put together to hear the case. After both sides present all their evidence and arguments, the tribunal makes a final, binding decision, which is called an award. So, when investors bring these cases, what are they actually claiming? What are the rules of the game here? Well, these treaties offer a few key protections, but let's focus on the two most common and, frankly, most powerful ones. First up is protection from expropriation. Now, this isn't just about the government physically coming in and seizing your factory. It also covers what's called indirect expropriation, which is where a government might pass a bunch of new rules that make an investment basically worthless without ever technically taking it. Now, under international law, a state can do this, but only if it meets some very strict conditions. Most importantly, paying fair market value for what it took. The second major protection is the guarantee of fair and equitable treatment, or FET. This one's a bit broader. It basically means the host country has to provide a stable and predictable legal and business environment. It's there to protect investors from having the rules of the game suddenly changed on them after they've already put their money in. So after months, sometimes even years of legal battles, the tribunal finally reaches its decision. What happens then? A tribunal's award is final, it's legally binding, and unlike most court systems, there's no real appeals process. This decision creates a direct international legal obligation for the losing party to do what it says, whether that's the investor or the state. But there's one last hurdle. Winning the case doesn't always mean you get the money. That idea of sovereign immunity comes back into play, just in a different way. A state's assets, think its embassies or central bank reserves, are often protected from being seized. So trying to collect the money from a country that doesn't want to pay can be a really complex final challenge. Okay, so now that we've walked through how it all works, let's zoom out. This isn't just some niche corner of the law. It's a massive, really consequential system that is under intense debate right now, both publicly and politically. And to really get a sense of the scale, just look at this number. By the end of 2023, there had been over 1,300 of these cases that we know of. And these disputes have involved nearly 2/3 of all the countries in the world. This is a system with a truly global reach and a massive impact. So why does any of this matter to the rest of us? Well, because these cases can involve billions of dollars of taxpayer money. They touch on a country's ability to pass laws to protect the environment or public health. They force us to ask these really fundamental questions about how we balance the need to attract foreign investment with the right of a country to govern its own people. And that brings us right back to the central, unresolved question. How do we balance the rights of investors with the nation's sovereign right to govern in the best interest of its people? Finding that balance, well, that's the ongoing debate that's shaping international law and our globalized world every single day.